The recent Supreme Court decision in Louisiana versus Callais effectively killed the last remaining provision of the Voting Rights Act of 1965. It was authored by Justice Samuel Alito, but it represents the life's work of Chief Justice John Roberts. The Roberts Court has now gutted the Voting Rights Act on 3 different occasions, and Roberts wrote or joined every one of those opinions. And that's not an accident. Roberts has been trying to kill the Voting Rights Act for more than 40 years, and it looks like he's finally succeeded. Roberts' crusade against the Voting Rights Act dates back to the early 1980s, when he was a young lawyer in Ronald Reagan's Justice Department. The Reagan administration was locked in a fight with Congress over whether to reauthorize parts of the Voting Rights Act and how strong the Voting Rights Act should be. Roberts took the position that the Voting Rights Act should be as weak as possible. Roberts claimed the Voting Rights Act would lead to a quota system in all areas, essentially comparing the law to affirmative action in the voting process. Roberts actually lost that fight in the early 1980s. The Congress overwhelmingly reauthorized and strengthened the Voting Rights Act with strong bipartisan support. But Roberts resurrected his crusade against the Voting Rights Act when he became Chief Justice of the Supreme Court in 2005. Roberts claimed in his confirmation hearings that the constitutionality of the Voting Rights Act was a settled question. But once he got on the bench, he quickly got to work in dismantling the country's most important civil rights law. In the 2013 decision, Shelby County versus Holder, Roberts wrote the majority opinion, ruling that states with a long history of discrimination no longer had to approve their voting changes with the federal government. He claimed that things had changed dramatically in the South, but in the wake of his decision, 31 states have passed more than 115 new voter suppression efforts. Roberts claimed in the Shelby County decision that his opinion in no way affected the other major part of the Voting Rights Act, Section 2, which banned racial discrimination in voting nationwide. But the Roberts Court quickly started attacking that part of the law as well. In the 2021 case, Brnovich versus DNC, authored by Alito and joined by Roberts, the Roberts Court made it much harder for voters of color to challenge discriminatory voting laws. And then in the recent Louisiana versus Callais decision, the Roberts Court struck down a second majority black congressional district in Louisiana and imperiled majority-minority districts all across the country, leading potentially to the largest drop in black representation since the end of Reconstruction. They have now narrowed Section 2 and the Voting Rights Act overall to the point of irrelevance. The defining cause of Roberts and the Roberts Court has been rolling back the civil rights revolution of the 1960s. And it's clear they're not going to moderate on this issue anytime soon. That's why, if you want to protect civil rights in America, we have to have a new Supreme Court.